Good afternoon, everyone. I'd like to welcome you to our episode number 2 of Association Matters. We are providing these for our current board members that we have at Lang Management Company and also to the outside. I understand there's a lot of others that are on this call and appreciate you coming into this today. We feel that education is so important for our board members, especially with many of the changes that have come into play July 1st and going into the future. So we have teamed up with Kaye, Bender, and Rembaum to try to bring as much information as we can to our boards in this session and future sessions that we will be holding to try to keep you updated on the latest, greatest, and also assist you in any areas that you may be struggling with or you think you need help in as a board member. So we encourage you at the end of this to please fill out the evaluation. Put on there any suggestion if you think it would be something that we could bring into a future association matters and help you serving on the board, because we are successful because we have successful board members who help us do our job and keep all of us informed. I really would like to thank Jeff Rembaum and also Alan Schwartzide, who is part of the presentations that we are going to be doing. Alan and Jeff worked very hard on putting these together for us, so a big shout out to them before we turn it over to them. Just a few reminders, this class has no CEU credits. So if you're a manager or someone looking for CEU credits, there will not be credits. This is all informational. It is not a legal representation or opinion. That's not why we've asked them to do this today. The purpose today is to help you better understand what just came through on the state statute. So, and I apologize, I should have introduced myself at the beginning. I'm Marita Butzbach. I am the Executive Vice President of Lang Management Company. We are a local property management company that handles communities from Port St. Lucie to Boca Raton. And we are hopeful that these sessions that we're going to provide for all of you, that you'll find them educational, informational, and appreciate us holding them. So thank you so much for attending today. With that, I am going to turn this over to Jeff Rembaum to start our seminar.
Associations for a minute. Talk about the My Safe Florida Condominium Pilot Program, page 22. Essentially, for every $1 the association puts in, state of Florida will give you $2 for inspections and work that comes out of those inspections that is necessary to shore the property up, shall we say. But there are limitations to the money. There's only $30 million in the pool. The maximum amount an association can get is $173,000. But there's limitations, like if you're using the money to help fix a roof, how much money they can get. But I did some quick math, and if each association got the full amount, then only 172 are going to get any money. Obviously, not everybody is going to get the full amount. I would imagine at the end of the day, somewhere between 500 and 1,000 condominium associations will benefit from this program. When the money is out, it's out. In order to make application for the money, the DBPR has to promulgate forms. They haven't promulgated a single thing yet, so there's no way to apply for this money yet. So there's a very quick understanding of the My Safe Florida Condominium Pilot Program in Chapter 215. I give you all kinds of other information in the outline. You can read it to your heart's content. I'm not going to take any more time on that subject today. We're going to jump into now House Bill 1021, dealing with all the changes to Chapter 718 Florida statutes. All right. First and foremost, remember that with the milestone inspections, there was an exception last year for 1, 2, 3-story homes that don't have more than 3 families in them. Now there's an exception for 1, 2, 3, 4-family dwellings that are 3 or fewer habitable stories. That's hard to say, but just think of a connected townhome, please. One building, partitioned walls, and it goes vertical, and it's not higher than 3 stories. So there's 12 units in this building, right? 4 on each floor, 3 stories high. it would be exempted from the milestone inspection. All right, enough said on that. Condominium hotels had an interesting year. You guys have a lot of condo hotels down there. I'll explain how the condo hotel process works, what the problem was, and how they fixed it in the legislation. Essentially, if you have a condo hotel, it's almost like having a timeshare, because the condo hotel owner tells the association how much money it's going to pay for the maintenance and repair each year of the hotel unit. So imagine this, a condominium declaration where all the common elements are now considered the hotel unit or the hotel operator unit. So the lobby, under the complete control of the hotel operator, not the owners. Follow the process so far? But the law says for a condominium, you have to have a common element. So the developer lawyers created units for owners, then all the common elements, the lobby, the elevators, everything becomes part of the hotel operators unit. And to comply with the statute, a tiny little conference room, a storage closet was the common element. Owners are upset about this because, well, they realize what a horrible investment this is. Anyone that ever came to me for purchase of a unit within a condominium hotel never ended up consummating the deal once I explained to them how the process actually works. But in any event, the court said, hey, you can't do that. That's against Chapter 718. So the developer lawyers got together, bottom of page 26, condominium in a building, and they rectified that problem with some legislation. I'm not going to go through it today. It's not important. I just think the concept of the hotel condo is an interesting concept to begin with. So you have units that owners buy. You take all the common elements and you call them the hotel operator unit, with the exception of one small little room somewhere that is an actual common element. And then in the governing documents, the hotel operator is responsible to tell the residential association owners how much money they have to pay each year for the upkeep and maintenance. And you can imagine the litigation that follows between the upset owners who are upset with the hotel operator about telling them how much money they have to contribute for the upkeep and maintenance of the hotel operator unit, which are essentially the common elements, but the owners get no say-so. Phew, that's a mouthful. If electronic voting, so if you offer electronic voting in a condo and the member says, hey, I want to vote electronically, you have to honor it. Apparently, there were some situations, I don't know, I didn't see them come up, but there must have been a situation somewhere where the association offered electronic voting, but then didn't offer electronic voting. So they created the platform, but didn't offer it in real use. So now if you do offer it and the member wants to use it, you have to offer it. That's all. Simple enough. Kickbacks, of course, are criminal penalties. The division of condominium now has jurisdiction. If the owner complains the association doesn't have proper insurance. Remember, we spoke earlier, the fiduciary duty of a board member, both condo and HOA, is reasonable business judgment. You might be wrong all the time in your decision-making, but did you act reasonably? And if the answer is yes, congratulations, you exercised your fiduciary duty, with one exception. In the condominium world, when it comes to the purchase of insurance, a director is held to the standard of best efforts, not reasonable business judgment. That is the highest standard in the law. You know, clients sometimes come to us and say, you know, insurance is too expensive. We want to do something different. My God, it's a best efforts standard. You better follow 718-111 when acquiring the association insurance and not cut corners. That's a recipe for disaster later. Official records. So an association managing a condominium with 25 or more units must have a website. 25 or more units must have a website. Same thing we discussed before about what records are supposed to go on the website and the privileged information that doesn't supposed to go on the website. I'm not going to cover that again. I will say that official records for condominium has been expanded to include all invoices, transaction receipts, deposit slips, et cetera, copies of building permits, copies of the satisfactory board member education certificates. As you'll see, a condominium board member has to take 1 hour of continuing education per year. 1 hour per year. The division now has jurisdiction to make sure that the association's records are organized. How many of y'all have I have a few clients like this where all the records are kind of basically tossed into a room, and that's the record room, but there's no organization to it from year to year. I've seen that, more than once over the years. Now there's an obligation for the condominium association to organize its records. There's clarification provided in the law that if someone makes an official record request and that record is available on the website, you can direct them to the website. We like that one. Here comes one you're not going to like. If a member makes a request to inspect the records, at the same time, the association must provide to the requesting member a checklist of all the records made available and all the records that weren't made available. What a pain. I think it's easy to have a list of the records we do have. So if you do have a list of all the records, that could fulfill half the duty. But then the other half is if someone makes a request for a record and you don't have the record, you have to put in writing, you didn't give them the record, you didn't give them access to the record. You didn't have the record to give them in the first place. Failing to produce or failing to provide access to the official records in furtherance of a crime is a misdemeanor of a second degree. You have to knowingly, willfully, and repeatedly fail to provide the official records. Knowingly, willfully, repeatedly. Repeatedly means twice within a 12-month period. All right, let's see. I'm not going to go to the next one. There's also a felony charge, but it's if you willfully, knowingly refuse to release official records with the intent to avoid, escape, arrest, trial, or punishment. So don't really need to go into more detail there. Required financial reports, same as in the HOA. If you're required to do a particular financial report and the members vote to do a lesser report, fine, but you cannot do that in consecutive years. Again, debit cards, you are not allowed to have debit cards, period. So don't have a debit card. You have to have 4 meetings a year. If you have 10 or more units, at least 4 times a year, the meeting agenda must include an opportunity for members to ask questions. Fine, the member has the right to ask questions, but still there's no obligation to answer. That's important because if you're dealing with that cantankerous member, got to let them speak, right? They have the right to speak for up to the 3 minutes, and they do it, they can ask questions. Fine, it doesn't mean the board has to answer. Practically, you probably do want to answer the questions, but if you're dealing with that cantankerous member, maybe not. So that's just an important thing to know. If the condominium board meeting agenda relates to approval of a contract, then a copy of the contract must be provided with the meeting notice and even made available for inspection and copying upon written request from an owner or made available on the website. Board member certification requirements. The certification is valid for 7 years. HOA is valid for 4 years. Go figure. There's still no lying approach, so that's gone, which is good, right? You can't say you read the governing documents, will abide by them, and faithfully discharge your duties. Have to be certified within 90 days of being elected or appointed. There are new course requirements. The board certification course must be at least 4 hours long. Let's see, that's enough there. Here, the proof of the board member certification certificate is held for 7 years by the association, whereas in the HOA world, it's a minimum of 5 years that you hold it in the official records. Structural integrity reserve study, top of page 31. Within 45 days after receiving it, you must distribute a copy to each owner. Easy enough, or let them know you have it and they can get a full copy from the association. Study was completed and the association provided or made available such study to each owner. You have to provide the Division of Condominium a statement indicating the study was completed and the association provided or made available such study to each owner. A director and officer is guilty until proven innocent if charged with forgery of an election of a ballot envelope, theft, embezzlement of funds, destruction or refusal to allow inspection or copying of official records in furtherance of a crime. There are fraudulent voting activities, very similar to what we discussed with HOAs a short time ago, where you could be charged with a misdemeanor of the first degree. So we've kind of covered that in HOA land, and these mirror, you can read them on your own, but moving on to maintenance and hurricane protection, section 718.113. In the past, there was a requirement that each condominium association adopt hurricane shutter standards. That's gone. Now it's hurricane protection standards. So chances are your condominium associations haven't done this yet. This is a takeaway. You need to adopt hurricane protection standards. There's all kinds of information in the outline regarding this particular subject and how the owners can.
Jeff,
Sorry.
Jeff, to interrupt. Martha has a
I have a
question.
question. Back to the websites. A lot of association members are asking, once these are up and running, will we be housing 7 years worth of records on there? And the approach is, do we need to go back 7 years and start loading everything? Or if they did a 40-year certification 2 years ago, we could obviously upload those reports, but it wouldn't be something that we now have to go back and comply.
That depends. If you want to be in a position when a member makes an official record request to point them to the website to say your records lie there, then you better have it all on the website. And I think we don't have clarity in the law, a definitive answer to your question, but good governance says, yeah, probably whatever the length of time is you're retaining the record. If it's the type of record that's being put on the website, probably ought to be there for the past 7 years if you have it. But you don't have clarity. If you're asking if the law says you must post the last 7 years, it doesn't.
And so everybody understands, in Jeff's opinion, we're looking at uploading 7 years worth of records onto these websites. It's
Well,
not,
over time, it makes sense, right? You start with today's stuff, and then maybe you give your associations an option. First, you got to ask the association's lawyer their opinion, right? So you're going in that direction. Do we have to post the last 7 years or not? Pending what they then come back and say, then you can give your client a choice. Right? This is not free. Your time is money. If you're going to be using your resources at the corporate level to put all this stuff together, I'm sure, posting last year's material as compared to posting the last 7 years' materials will have different price structures to it. Well, not sure, but it would just kind of make practical sense, I suppose.
I think you answered it. I think it can be viewed either way, but definitely putting it out to the association board to make a decision, then we need to know how to proceed from there.
Yeah, I mean, I definitely start with the most current stuff for sure.
Got it. I mean, they could always request the other records that we have, but
Correct.
I mean, to make things easy, obviously in the future, having all 7 years there is super easy because you don't have to even talk to them.
Yeah, it's a good question. And over time, it will become 7 years naturally. Now, every year that goes by, that year's records is already there, so over time, it'll catch up to itself for sure. The board may, with the approval of the majority of the voting interests of the condominium, install or require that owners install hurricane protection that complies or exceeds the applicable building code. A vote of the owners to require the installation of hurricane protection has to be set forth in a certificate. The reason I'm saying this is there are processes to follow regarding the hurricane protection and making sure all of the apertures, all of the openings comply with that hurricane protection. There is, and you can read a lot of this on your own for the nitty-gritty details. There is a little bit of a discrepancy when, and you're going to have to go to the association lawyer on this, if you're doing structural work and the hurricane shutters have to come off, who pays?
association.
The general rule of thumb is if it's an owner installed improvement, the owner is responsible for the cost of removal and cost of replacement in the event the association needs access to that area. But now the legislation says that's an association responsibility. So, different lawyers may feel different, but if the declaration says in plain English that it's an owner responsibility to remove and replace when the association has to do its maintenance and repairs, then it's going to be, I would follow the language in the declaration. But if there is no language in the declaration and it's silent, it appears the old rule is gone developed from court cases and such. And the legislature says now that's an association expense. But again, that's going to have to be handled individually with the lawyer for that association. So all kinds of great information on hurricane protection. The takeaway is you need to adopt hurricane protection standards, and then all kinds of other information in there as well to give you some guidance, general guidance on the process. Statute of repose is a big one I want to talk about real quick. Statute of repose is, even though you're within the statute of limitations to bring your construction defect lawsuit against the developer of the condominium, if you're outside the statute of repose, you can't bring the case. What is the statute of repose? Very simply, when I first started practicing law, it was 15 years. So you cannot bring a lawsuit for a construction defect if it's been 15 years, in the old days, from the date of the temporary CO to the date you file the lawsuit, if it's been greater. Now the statute of repose is 7 years. There's a problem. Think about it. When they changed this law last year, the statute of repose was 7 years. You're a recently turned over condominium association. Sales were slow. The developer turned over in year 7. That's the dead drop deadline to turn over control to the owners. So they did it in year 7. The association diligently hired an engineer. They found the defects. So they found the defects and filed a lawsuit within 4 years from the date of turnover. They're within the statute of limitations, but they're outside the statute of repose because it's been greater than 7 years from the date of the temporary certificate of occupancy, when the owners can first move in, to the date you file the lawsuit. Therefore, even though you're within the statute of limitations, statute of repose deadline means you can't file your lawsuit. So any I feel sorry for any condominium association that turned over last year, because only effective July 1st, 2024, the statute of repose begins to run from turnover too. So now we have protection for those condominium associations. But for those condominium associations that turned over in the last couple of years, when the legislature made the statute of repose 7 years, if they turned over late, they have significantly less time to file their defect claims. So watch out for that. That's a big one. Slap suits. No, it doesn't mean you can go slap the residents. Sorry, it doesn't mean that at all. A slap suit is a retaliatory lawsuit. The term is borrowed from government. Government can't file a retaliatory lawsuit against someone that's driving them crazy. Well, we borrow that term in the condominium sense, and now it is prohibited for an association to take certain retaliatory action against a member who complains in good faith to a governmental agency, or has organized or encouraged a unit owner organization, or has filed complaints against the association, or has exercised their rights under Chapter 718, or if they complain too often, or if they make public statements critical to the operation or management. You can't threaten, defamation, libel, slander, tortious interference if the member is acting in good faith. So the association has to take a position that the member was acting in bad faith when they did these things, and therefore the association can file their defamation, libel, slander, or tortious interference action against that member. But that's a pretty big, you know how members sometimes post things on the Facebook account or what have you, and it's defamatory as heck, and you want to have the association lawyer send a letter. It's going to get a lot more dicey now whether or not that letter can be sent and things like that. If there's actual litigation going on, this particular issue is advanced to the front of the judge's calendar to decide whether or not the association could bring that counterclaim. All right, let's see, conflict of interest. We have clarification that a director who has a conflict of interest still counts toward the quorum, so that issue has been resolved. If you're going to suspend an owner's rights to vote, you have to do it at least pursuant to the statute, at least 90 days prior. But here's something I bet you didn't know because you don't get Rembaum's roundup. Court case came out not too long ago. It said you cannot suspend a member's right to vote if you don't have that specific authority in the governing documents. So watch out for that. If you're going to suspend a member's right to vote, you can't just rely on the fact that the statute says you can do it. You need to have it in the governing documents themselves. And then we have expanded jurisdiction for the division of condominium, including all sorts of financial issues, of course, elections, maintenance and access to official records, procedural aspects of meetings, quorum requirements, budget meetings, conflict of interest requirements, integrity reserve study, the association didn't do it, complaints about that, removal of directors and officers, et cetera. Division is now obligated to coordinate with law enforcement if they have proof of criminal activity, and any member of the division or the ombudsman's office has the statutory right to attend board and membership meetings, even though they are not members of the association. Finally, we'll finish with the Corporate Transparency Act. This is coming from the United States Department of Treasury, FinCEN committee, if you will, within the Department of Treasury. You know the requirement that says banks have to, anytime someone deposits more than 10,000 a year, they have to give the name to the government. Well, this is the same agency. They're trying to track money going towards terrorism and other illicit goods, and somehow we got sucked up into this. Essentially, it requires the name, address, and piece of identifying government issued identification, such as copy of driver's license or passport, to be uploaded to the FinCEN website. If you are a business entity that has to coordinate with your local state Department of Corporations, then the beneficial owners of that company now have Department of Treasury FinCEN requirements as well. These requirements go into play December 31st this year. It doesn't matter if you've gone to great length to keep your name and address out of the public records. You must provide your name, your address, and a photocopy of either passport, driver's license, and a couple other things to FinCEN. There are significant penalties for failure to comply. Who's going to do this? Will the management companies do it? Will the lawyers do it? I've already decided my firm is not going to do FinCEN registration. I don't want copies of people's driver's licenses and passports in my office. So there are other third-party companies out there that do these registrations. I would suggest coordinating with them, but this has to be begun to be complied with by December 31st. Once you do comply with it, then anytime there's a change on the board, you have to notify FinCEN within 30 days and upload the new information. So it's up to date. Here's where it gets interesting on this one. There was a court case. A business administration on behalf of their business owners filed a lawsuit against this law, and the court ruled this law was unconstitutional, but only as to the plaintiffs in that litigation. So those 27,000 businesses got exempt, but they didn't go further than that, sadly, for the rest of us. So we're all still stuck with it. But this is the takeaway I want you to know. When we elect our legislators, right? And then they create agencies, and they give those agencies the power to adopt rules and regulations. But those rules and regulations show up in the code of the CFR, the Code of Federal Regulations, and they're essentially laws, as if Congress passed them. And there was a case a number of years ago called Chevron from the United States Supreme Court that basically gave these agencies broad rulemaking, broad lawmaking authority. It's where the Fair Housing Administration gets its rulemaking authority for the assistance animal. I'm a huge believer in pets. I love doggies. I'll always have doggies. But I also believe if you chose to move into a no-pet community, you ought to be able to live in a no-pet community with the exception of a true service animal, right? Someone's blind, hearing impaired, they have panic, those attacks where the breath changes first, and then the animal catches it and lets the owner know about that. I mean, those are important types of service animals. But the emotional support animal in the no pet community drives me crazy. Jeff is depressed. It affects him at work. Having the animal at home makes Jeff more productive at work. That letter could be written by a doctor, psychologist, social worker, mental health worker, or any other qualified individual, and I win. I get my emotional support animal. Why should there be an emotional support animal in a no pet community? Because the FHA, somebody that's individual there, drafted a rule, and that rule, when it gets passed by the agency, becomes a law, and now we're all stuck with it. So the EPA came out with a rule, which is a law, that this fisherman company had to take inspectors on their boats. And it was a real inconvenience to the fishing company. So they challenged the law, and it went to the United States Supreme Court, and it just got decided several weeks ago. And it's a fantastic decision because it overturned Chevron. It says these agencies can't have unbridled rulemaking authority anymore, that they can go too far. So I'm waiting for a courageous soul to challenge both this one, the one we talked about, Corporate Transparency Act, just a minute ago, and more importantly, even to me, is challenging some of these rules regarding the emotional support animal. Only time will tell, but at least the predicate is there, because the Supreme Court said in that fisherman case to the EPA, sorry, EPA, you went way too far. You can't do that. So, yay. Anyway, so there's a little constitutional history lesson for you today. Hope I didn't confuse anybody with any of this. If I did, read the material. If I didn't read the material, you're going to have to read it a couple times for it to soak in, set in. Remember, nothing today was applicable to any of your communities. It was just general advice. If ever I can help your associations, my personal client base is the state of Florida. I have clients everywhere. So if you want me or any of our lawyers, just shoot me an email, and I'm glad to get proposals out.
Thank you so much, Jeff, for all that information that you have provided today. We truly appreciate it. We're looking forward to future seminars with both you and Alan and Kaye, Bender, and Rembaum. Thank you, everyone, for coming today. We look forward to seeing you at a future one of our Association Matters episodes. Feel free to reach out to me if you have any questions about land management or questions that I can help you with that were not answered outside this seminar today. Thank you again.